All right, all right, all right. I want to welcome you. Can everyone see me okay? Can you see me okay? Let me know in the chat if you can see me. Perfect. So I want to welcome you to 180 Contracts Lunch and Learn. This is our first ever Lunch and Learn. It is for quarter one. This is a new initiative that we are launching. So I definitely want to hear your feedback. We are streaming on Facebook right now. We are also we're in Zoom. And so if you register, you will get access to the replay. And just to let you know, we're going to do this in two parts of the replay of the recording. So we're going to do the live recording of the Lunch and Learn. Then I'm going to shut down the live recording on Facebook. And then we're going to do a separate recording for the Q&A. So the Q&A is for everybody who registered. If you submitted questions, I have your questions. If you have questions as we go through the Lunch and Learn, please write them down or save them for the Q&A portion. That's going to be recorded and you will have access to it. All right. So let me officially welcome you again to 180 Contracts, our Lunch and Learn, and we are talking contract tips for business success in 2025. So first, let me introduce myself. Some of you know me, some of you don't. So if you are joining us, tuning in, make sure that you introduce yourself in the chat. Tell us where you're tuning in from and what are you munching on? What's for lunch or brunch, depending on your time zone. So I am Shayla Jackson. I am a trademark and business attorney, but I am also the CEO and founder of 180 Contracts. 180 Contracts is a contract template company for small businesses, freelancers, and entrepreneurs. And we provide attorney drafted contracts that are the next best thing to hiring an attorney without breaking the bank. And so I have been very intentional with our company, making sure that what we do and the policies that we create actually help small businesses protect your business with contracts so that you do contracts right. And that includes our buy one, always get all updated versions included for free as long as you stay connected. Because the reality is, as a small business, you're building your business, and we want to make sure that contracts don't take money out of your bank account, but help you keep money in as you sign those contracts. All right. Now, one of this initiatives is education. And so this Lunch and Learn, this is a conversation. This is not a webinar. This ain't a presentation. This ain't where I'm going to lecture you. It is a conversation. Welcome, Bobby. Welcome. What you chewing on and where are you tuning in from? And so it's a conversation. So I want you to relax. I want you to get comfortable. And so we're going to jump in. I'm going to try to get you in and out within 30, maybe 40 minutes, depending on how Q&A goes. But I have about 15 tips that I want to share with you. Some of it pulls from some of my experience with my clients, what I've seen them do bad that I want to help you avoid. Hey, hey, hey. Oh, an egg and avocado breakfast sandwich. Look, oh, I just bought some avocados. I'm ready for some guacamole after this. All right, so let's jump in. We are talking contract tips for business success. So if you see me, I got my notes because I didn't want to miss anything. All right. So if you're on Facebook and you're watching this, make sure you share this and make sure you go follow 180 Contracts on Facebook and YouTube. I couldn't stream live there because I don't have enough followers, y'all. So make sure y'all help so I can stream live there. All right, so let's jump in. Contract tip number one is your name, your personal name should never be at the top of a business contract. Period. Okay. So here's the thing. When you are in business and you are doing contracts, if your name is at the top of the contract, you are personally liable for that contract. But when the business is at the top and you have an LLC or a corporation, that means that the liability protection of your business actually protects you. And so you want to make sure that your contract is doing what it's supposed to do. And that means that in order for it to do that, you have to have the right name at the top. If the right name is not at the top, that means you're on the hook. So I had a client who made this mistake. They came to me, the other party was threatening to breach the contract, and they were trying to decide whether to come out of the contract or not. So I look at the contract and she signed their contract. And when I saw it and I read the terms, I said, do you realize that your name's at the top of the contract? And if you terminate this contract, you personally are going to be on the hook for $20,000. The other person didn't do no work. But because of the way the contract was worded, she would have had to come out of her own pocket for 20K. Do you have 20K lying around that you can just give somebody personally out of your money? Chances are you don't. And if you do, you still don't want to give somebody 20K out of your money. And so you want to make sure if you have an LLC or corporation, put the name at the top. Now, one of the questions you may be wondering is, well, where do you put your name? At the bottom of the contract when you're signing, and always put your title. When you are doing contracts in a business capacity, you want to put your title when you sign in the signature block at the end of the contract, because it signifies that you are in your representative capacity as CEO or founder, and not in your personal capacity as you as an individual. All right. And so another question you may have is, some of you do business as DBA. So you have other names that you go by for your business. Whatever your name is as incorporated with your state, that is the name that should be at the top of the contract. Now, how do you differentiate your businesses? Well, behind that, you put DBA, and then you put the name. So if you have multiple businesses, but you have one LLC or a corporation, you put the official name, and then behind it, DBA, and the name that you're doing business as. Now, here's a mistake that I've seen others make, is that they put the name of the business. That's not how it's registered with the state. Make sure you put the actual state. All right. Now, for y'all that's on Zoom, you can put your cameras on if you want to. It's not going to bother me if I see you munching and chewing. I'm actually looking at the gallery view, so I would love to talk to you because it is a conversation. But you don't have to. There's no pressure to. All right. Tip number 2 is negotiate before the contract is signed. Negotiate before the contract is signed. Once the contract is signed, all of your bargaining power is pretty much null and void. But people have incentive to agree to some of your demands because they're trying to close that contract. So if somebody gives you a contract and your personal name is at the top, you negotiate for the change. If there's something in the contract that you don't agree with, especially intellectual property, this is the time you negotiate before the contract is signed. That's where your bargaining power is. So you want to make sure that you're being successful by negotiating what's in your best interest. Let me tell you a secret. When I draft contracts for my clients, I don't draft with the other party's interest in mind. I draft with my client's interest in mind. So that contract is leaning heavily towards the party who gives you the contract. Now, here's the mistake that some DIY contractors do when you're trying to draft your own contract. You try to be equitable, and you try to be fair, and you try to draft the contract as win-win. Baby, this is business. When you try to do that, what happens is you undermine your own interests trying to be friendly and nice. You always want to make sure your interests are covered. And if you're using someone else's contract, this is where you negotiate to make sure what you need is in that contract. And if they won't budge, this is a time where you walk away. Walk away. All right. Now, I didn't have this on my list, but since it's coming up, I'm going to add this. Some of you have discernment. Stop moving forward with a contract once you discern that this is a bad seed. Because look, legal problems start as people problems. When people show you that they are late, when people show you that this is going to be a problem, this is the time to walk away before now you're dealing with a cease and desist, a lawsuit, somebody acting up, a client from hell. You have the power and the position to close hell out of your business before they became a client. Don't be so desperate for the money and the sale that you don't realize some people will cause you more problems. Because once you get into the legal realm and problems, how many of y'all are CEOs of one? Like, it's just you right now on your team. You might have contractors, but it's really you. Okay, I see 1 hand, 2 hands, and you can put in the chat. I see some thumbs up. Okay, when you are away from your business, like, what's happening with your business? Are you able to still make money? I don't think y'all realize how much time it takes to be in court or dealing with a legal matter. And it's not just the time, it's also your mental health. Sometimes that puts a lot of strain and it impacts every other area of your life. So when you discern that this ain't it, something feel off, ask questions, do research, look up their business in the state registry. Because sometimes if they don't have a history of paying their taxes and keeping their business in good standing, that's a key sign that they may not be keeping on the up and up and be integral in other areas of business. You can save yourself a lot of time, heartache, money, and stress. All right, that wasn't there, but I'm going to put that there. All right. If you are watching on Facebook and you signed up, make sure you get in the room, because I'm only going to do Q&A inside the room. All right. But hey, Megan, thank you, honey, for joining. All right. Tip number 3, use a e-signature software. Use a e-signature software. I just had a recent breach of contract case where the person signed the contract, but not through e-signature. So we don't know, it was just a typed signature. We don't know nothing. We don't know nothing about a typed signature on a sheet of paper. And so what that does is that if this contract, if someone ever wanted to challenge the contract, they could say, well, that's not I didn't do that, because there's no track record. So when you use an e-signature software, if you've ever seen it, they give you a certificate, but they also put something around the signature to let you know that there's a tracking for it. So you can track it to the email address. You can show proof that this person actually signed the contract. So use a e-signature software to get your contract signed. Tip number 4, keep track of important dates, your responsibilities, and timelines. Create yourself a cheat sheet. Okay, so you want a cheat sheet of all of your contracts in one place. I'm the type of person, I need it in one place. I don't want to be going all over the place. And so you want to keep track of what are your responsibilities, what are some key dates and timelines. So key dates may be, say for instance, you have a contract that has a renewal period or option. So you can renew the contract, but you have to give notice by a certain date. Sometimes it's like 30 days before the contract expires. You want to have that date somewhere that you're reviewing periodically to know when do you have to submit that information. Some of your contracts, it should have there, if you need to terminate the contract, how many days notice do you have to do that? That's a key deadline that you want to keep track of so you don't miss it. And one of the things I like to do, just when I'm keeping track of key deadlines, is put it in my calendar. I put it in my calendar and I set the reminder for a month out. Then I set another one for 2 weeks out. So I give myself plenty enough time to get to it, because we know we get busy and we forget things. You leverage AI, use Alexa. Alexa, set me a reminder. Alexa, don't send me a reminder right now. But that's what you want to do, right? Like, use your tools to stay on top of things. If you know you're busy, leverage it. All right, that's tip number 4. Tip number 5, you need to have a storage system for your contracts. So if you are signing a lot of contracts, you need to have a place where you can store it. So if you are a service-based business, you typically are having clients sign contracts with you. You should be anyway. And so you want to keep track of where are those contracts being stored. If you are doing an e-signature software, they're going to be sent somewhere. So you can create a folder where you store it. Now, when it comes to storing, you usually, the rule is stored in 3 places: a physical place, a digital place, and somewhere that's not connected to the internet at all, such as a backup hard drive. But at anything, you want to have a place where you store your contract. So if you need it, you're not shifting through your email trying to find it. You can go exactly to the folder to find that contract. Now, with that, you may want to have a filing system. How do you name it so that you can file it? One of the things I would do with my law firm clients is all of my contracts start with engagement letter, but I would put the company name, and then sometimes I would put the month and the year that this letter, the contract was signed. That way I can tell when I'm going through all of my contracts, okay, because some clients may be repeat clients. Well, what month and year did this come in from? So I can go find the exact one if I'm looking at my CRM to see where it is. All right, so that's contract tip number 5. Contract tip number 6 is, how many of y'all have had phone conversations with clients? How many of you follow that up in writing? I got one. Yeah. You don't know how much this is a sticking point until a legal issue happens and it's he said, she said. Tip number 6 is follow up your verbal conversations in writing. When you have a conversation with someone, you want to follow that up immediately with an email that says, thank you for talking with me today. And you want to actually identify the people that were on the call. Because let me tell you something, some of y'all don't remember what you ate last week. Some of y'all don't even remember what you did yesterday. It just happens. You are not going to remember what happens 2-3 years down the line or what that conversation is. Maybe you will, but some of the details may be fuzzy. And when it comes to, if you have to go to court, you want to be able to recall. Your email can be used to refresh your recollection in court if you're on the stand to testify. So use your email to follow up with them. Hey, thanks for meeting with me today. If you do it the same day, the date of that email is going to be there, so you'll know the date of the call. Thank you. We were on the call, and I thank you for your your CFO. Toki was on the call. I'm just putting you out there, Toki. Was on the call, and this is what we talked about. At the end of the email, you might want to say, if you disagree or, if there's anything in this that, you want to add, please follow up or confirm within a certain time period. That way, if somebody decides to challenge it, well, you didn't follow up. You had an opportunity. So you want to follow up verbal conversations because I got to remember attorney-client privilege, y'all, so I can't say that. There are certain things I can't disclose about certain cases. So I was about to say something. But you want to make sure that if there's ever a conflict with your contract, that people can't lie on you. And that's where the follow-up email comes from. All right. Contract tip number 7 for business success: keep receipts. Keep receipts. Your emails, every email you have for clients, it should go in your client folder. Keep your receipts. And I'm gonna tell you how long you should keep your receipts for when we get to tip number 14. Yep, corporate. Look, government taught me that. Okay, ain't nothing like getting in trouble when you in government with your supervisor because you got to go ahead, but then somebody got angry because you holding them accountable to do their job. Baby, keep receipts. Keep receipts. Because if a client comes back and say, well, you didn't deliver X, Y, and Z, you can point back and say, no, I delivered it on this day. And here's the thing, for some of you, depending on what you're doing, you may want to look at software that will have them sign for approval that they received the actual deliverables. That way, there's no confusion, and it will help you if there is a chargeback, they dispute the charge. Now you can fight it back because you got proof. Keep your receipts. All right, we are on contract tip number 8. If you're just joining us, welcome. Make sure you introduce yourself in the chat. Tell us where you're tuning in from and what you are munching on. All right, we're having a conversation, lunch and learn, shoot. And feel free to turn on your video. Again, it's a conversation. You're not going to be on camera. It's just me. I believe that's on camera. You can't see nobody else. So you're safe. You're safe. All right, contract tip number 8. Y'all. All right, so I come from a criminal defense background, okay? I also did e-discovery for many, many years, which means I looked through a lot of emails that companies would send and all documents when there was a litigation. Because whenever there's a lawsuit, there's discovery. And you see a lot of, let's say, unfiltered and people put a lot of stuff in emails about folks, okay? So my tip for you, number 8, is only put in writing what you don't mind showing up in court. Only put in writing what you don't mind showing up in court. Now, this ain't for the folks that's trying to violate the law. That's not the people that I talk to. But let me tell you something. Only put in writing what you don't want to show up in court. Some things need to be a telephone call. I have done that with clients before. We ain't put nothing in. You're going to call me because we're going to talk this out. And here's the thing. I know I gave you tip number 6, which is follow-up conversations. Use discernment. I don't follow up them conversations in writing. It goes in my CRM. I talk to the client, but that goes into my notes. But I also have privilege for certain things. So you need to be mindful of certain things. I'm not telling you violate the law or do anything like that, but only put in writing what you don't mind showing up in court. That means that, don't be talking about your clients behind their back and then all of a sudden they find out and now your stuff is plastered all on the internet because they got discovery and they showing, You just don't want that. All right. We don't know the consequences of that. All right. Tip number 9. How many of you have policies for your business? Like your clients come in or your customers come in and you have a policy either for behavior, your communication policy, how many of you have policies? You can either do a raise a hand or you can do, I think you can react with an emoji or hand thing somewhere in Zoom, or you can type it in the chat. If you have a policy, okay, if you have a policy of how clients are supposed to interact with you or how your business is supposed to operate, how many of you have that policy in your contract? Because somebody can violate your policy, but not be in violation of your contract. We're talking about contract tips for business success in 2025. Welcome, Kenneth. Welcome. If you want to be in the Q&A, it's not going to be aired online. You can register and still get access to be in the room. All right. So somebody can breach your policy and not your contract because you didn't put it in the contract. And so one of the things is I have a communication policy and it's in my legal contract because some things require deadlines. One of the things that I noticed early on, because as you do business, you'll find out some things just don't work for you. I had clients that were going ghost. Like, what you doing? All I asked was for, are you okay? Are you alive? Tell me something. And especially in the world with COVID and everything going on, you want to know, are you still living? I know life is happening, but at least communicate with me that we're still okay. At least tell me that you're going to get back to me on these contract reviews. And so what happens is that I started adding things into my contract because I had a communication policy. You need to respond to me within these certain days or I terminate the contract. So how do you do this? By giving yourself the freedom because you might change your policies. Well, you do it like this. You add a clause into your contract that says that the client, or if it's not a client, but the other party agrees to abide by your policies. And not just abide by them, but abide by the policies as of date and any policies as they are updated. Because you might update your policy. So rather than having them come back and say, oh, no, as they're updated. And then here's what you do. You also have to give them a copy of your policies. Now, I believe in efficiency. Find a Dropbox where your policies are or Google Docs where you can update it and just have a link that they can go to and see the policies. But the other thing that you may want to consider, depending on where you are in your business, is giving them a sheet that they have to sign or having something they have to sign that says they have received, they acknowledge, and they agree to abide by the policies with the date. This is the way where your contract doesn't get bulky or overloaded with your communication policy, rescheduling policy, any other policies you have, but you can still hold the client accountable to following your policies. Because let me tell you something, you get that wrong client, it's going to teach you what your policies need to be, because your policies are the boundaries in which you operate your business and keep everything flowing so you can serve more people. All right, so that's contract tip number 9. Contract tip number 10, document problematic behavior, violations of the policies and the contract. And you don't just want to document it, you also want to give corrective action. So when somebody is violating either your policy or they're violating the contract or they are just acting problematic, you want to, I don't know if anybody is afraid of conflict, but this ain't where you get afraid of conflict. You want to address the behavior immediately. Now, not if you angry, simmer down, use emotional intelligence, but you want to address the problematic behavior in the beginning. And then when you address it, use all of the communication theories and all of that. Don't say you and people get defensive with you, be wise about it. But you also want to say, hey, this is a problematic behavior. It also violates this part of either the contract or policy. And I would love to continue working with you. In order for us to do that in a safe environment or in a way that works for the both of us, here is the changes that need to be made. Here's the corrective action you can take. And if they don't take that corrective action, then you can say, hey, let's have a phone call and let's really discuss what's going on. Because what you're doing, and then you follow up that phone call. Remember, follow up the phone call in writing. Because what you're doing is you're laying out a history that when you need to terminate that contract, now you have a basis for doing that. That's not rooted in your feelings. That's not rooted in wishy-washy. You have evidence that they have been in violation. And what you're doing is you're putting proof to it. Here's the violation. Here's the policy. And you remind them. Now, here's why this is also important. Because you'll have people who will give you a bad review. And you'll have people that say all manners of things. And you can look back to the history and say, actually, no, you were problematic. And I tried to give you grace and corrective action. So this protects you as a business owner, because now you might forget, but now you can come back to the record and see it. And let me put this in corrective behavior. You also want to document this in your, if you have a CRM or wherever you are tracking your clients, you also want to put it in their record and file, because if you are sending multiple emails, you don't want to have to go through all of the emails. You want to have it in one place where you're keeping notes for your clients. So you can go, okay, this infraction on this date communicated. They didn't, just take your notes. They didn't take corrective action. All right. Tip number 10. Nope, we did 10. Tip number 11, terminate with professionalism and integrity. Don't be afraid to terminate that contract. Just make sure you follow the termination procedures. So whatever notice is required, give notice, and give notice according to the notice procedures. If notice is missing from the contract, that's a big flaw, because every contract requires notice. Now, if you're asking the question, what is notice? Notice is literally what it sounds like. It's giving you notice. You notice, hey, I'm giving you a heads up. I'm telling you this is what's happening. I'm terminating the contract. Typically, notice is in writing. Now, if you got some contract off the internet and you didn't have a 180 contracts template, chances are they limited you to certified mail and postal mail. Now, if you got a 180 contracts template, you got email as an option, because the reality is that we're in a digital age. And how many of y'all going to the post? I mean, I still go to the post office, but how many of y'all about to go? Certified mail costs. Email does not. Certified mail costs, email does not. And so in the contract, notice should not just be how it's sent, but also when notice is effective. Because how many of you have missed emails? How many of you have not seen mail in time? So notice has to be effective, and you want to know when is it effective, upon receipt or anything. How many of you have received an email delivery error? That's why one of the contracts in our contracts, it says that if it's sent by email, it's not effective if you receive an error delivery. So you can be creative about how you write that, but you also want to have it in your contract. All right, we're coming down to the end, and then we're going to get ready for the Q&A. Contract tip number 12. We're getting into the substance now of the contracts. You can send through email. You can send through fax. The one thing about contracts, so we got some folks on Facebook. So there was a comment in the chat, and it was, they still go to the post office, but they didn't know they can send notice via email. Yes. When you write a contract, you can be creative. There are some things you might not know about contracts. So if you ever seen like an old school contract, it has a definitions section. You can make up definitions for your contract. If you want yellow to mean blue, that's exactly what it means when you see yellow. If you want sky to mean grass, that's exactly what it means when they see that in your contract. That's the power of drafting your contract, is you get to decide what you want in it and what you don't. And here's the thing you might not know. If your contract is clear, there is no ambiguity in it, courts are not going to interfere with your contract. Courts are not going to interfere with your contract. And if they do have to interpret something, they're going to do it based on a reasonable person standard. What would a reasonable person think this is in this contract? And so that leads us into, we're getting into the substance of the contracts now. That leads us into tip number 12, which says clear terms and consistency. You want clear terms and consistency. How many of y'all have children? How many of y'all have children? How many times have you told them to do something and they found a loophole through it? How many of you found a loophole through it? Hey, Rhoda, hey. If you want access to the Q&A, make sure that you register for this. You can go to bit.ly/Lunch and Learn 2025 and still get access to the room. Q&A is only going to be in the room, right? A loophole. Let me tell y'all something. When I was young, my mother grounded me. And she told me that I couldn't watch TV. Yeah, I got my aunt on here, y'all, so she know my mama. She told me I couldn't watch TV. We were living in my grandparents, and the downstairs bedroom, you can hear the TV. They watch it loud. So I'm like, I'm sitting in the room, like, I'm listening to the TV. I'm listening to the TV. So what's the point of that's all right. So what did I do? I closed my eyes. I walked into the living room. I turned my back to the TV and I sat down. And when she came downstairs, she was like, I told you not to watch TV. I said, I'm not watching TV. I'm just listening. I'm not watching it. I follow the instruction. I'm not listening. I mean, I'm not watching it. I'm listening. Hey, Lavani. Hey, girl. I'm not. I'm some of your contracts are like that. They got loopholes. Somebody can find a loophole in your contract because it's not clear and it's not consistent. So you want to, when you need to get clear, you need to keep asking yourself questions. Is there another interpretation for this? Can somebody interpret this a different way? Is there another, do I need to define some words? Do I need to add some clarity here? I'll give you this example. Some folks do coaching. And so they think that clear is, I'm going to provide you with 3 90-minute coaching sessions. That sounds clear, don't it? That sound clear? That sound clear. It sound real clear, don't it? What happens when one of your sessions don't go 90 minutes? Did you breach your contract? Do they have a right to a refund? Because what you promised was 3 90-minute coaching sessions. So how do you get clear? 3 coaching sessions up to 90 minutes each. See, the up to means that if we go 60 minutes, I still fulfilled my obligations. But if you promise 90 minutes, you got to perform 90 minutes. Up to, right? So you want to think about, okay, am I locking myself into something? Is this really clear? Because what we think is clear is not clear. I don't know if y'all ever saw this video. I love it because it shows the creativity and the analytical mind of children. There was a rule in this family's house where they couldn't eat in the living room and they couldn't watch TV in the kitchen. And the kitchen and the living room were together. So the little boy had his food. He was laying across the line, and he had the tablet in the living room, and he was laying in the kitchen eating. And so technically he was following the rules. He was able to do what he wanted to do and follow the rules. You want to make sure there's no wiggle room in your contract, at least for the client. Now, for you, you want grace. You want to make sure that there's wiggle room. But when it comes to clear terms, you want to ask yourself, am I locking myself into something that I'm not going to be able to actually deliver? Is there another way that I can redraft this to give myself some wiggle room? All right. And then I say consistency because when you read through your contract, you shouldn't be having, you promise one thing here and it sounds like something else there. And it's not just the contract, it's also your sales policies. If your landing page promises one thing, don't have your contract say something else. Because now what you're doing is you are creating inconsistency and possibly a breach of contract because your sales policy is also a contract. So you don't want there to be inconsistency across the board. You want everything consistent. If you promised it, you got to be able to deliver it. Now, I'm not here in my other hat trying to go through marketing and advertising laws, but you don't want to get an FTC violation or somebody reports you for false advertising because you didn't deliver on what you promised. All right. And with that said, let me just say this. Don't be offering no 100% guarantee or money back if you're not going to actually do it. Don't do that. Don't do that. Because if you say it, you got to back it up. All right. Contract tip number 13. All right. If you listen, tune in. This is where you need to tune in. All right. How many of you do business across the United States or globally? I do. Yep. I do. What does your contract say about where litigation must take place? Yep. Look, Candace, no. Where must litigation take place? If somebody got an issue, where do they have to bring it? Does your contract say that? Does your contract say anything about it? If it doesn't, you have opened yourself up to be sued wherever your client is. Now, imagine you got clients in every state in the United States, and whatever happened, something got in the food and everybody decided to sue you. Do you have the bandwidth to travel to every state to litigate? Do you have the money to hire an attorney in every state. Can I just tell you something? Attorneys are licensed in states. We can't practice in every state unless it's federal law. That increases your legal fees. It increases the cost of litigation. It increases expenses. We're talking about flights. We're talking about hotels. We're talking about food. We're talking about you being away from your family. So if you are a single parent, you got to get babysitting. We're talking about, I mean, just think of the stress. We're talking about, oh, flights getting delayed. So now you late for something. We're talking about, again, many of you are CEOs of one. We're talking about how you in court. You cannot have your phone in court. That means that even if you could think that you can operate from your phone, you sitting in court waiting. I can't tell you how many hours I have just sat in court just waiting for my case to get called when I was going to court and in trial. Which means you can't operate your business unless you hire somebody to help you. All of that is the cost that you don't consider if there is a legal issue, a lawsuit, or any of that. So how do we do that? Well, I want to talk to you about contract tip for business success in 2025. Baby, I love this one. It is number 13, and it's called a venue selection clause. A venue selection clause. I don't know if you watch sports, but it's something about home court advantage. When you are home, you get an advantage. This is what venue selection clause does. It says that if any litigation takes place, it has to be brought here in my home court. And what's your home court? It's your county, and it is also your state, your county and state. Because for all of my folks from Maryland, we know that Cumberland County, Frostburg, is so far away from Montgomery County. It is a distance. That's about 2-3 hours. And you know what in Texas is huge as well. You don't want to be driving. That's miles, car. It's wintertime, black ice, traffic on 495 and all. Home court advantage. Now, there's some other language that you need to be in there because courts only have jurisdiction over the people who are within their borders. So you have to have the right language that if you are in Texas and you have a New York client, that you allow the court to reach over to New York and say, you have to come into Texas court. We have the jurisdiction. You put that into your contracts, okay? All right. Now, contract tip number 14. Oh, I love this one. Y'all gonna love this one too. It's called limitation of liability. Ooh, ooh, ooh. I read a case, and this is when I decided to add some more stuff into the 180 contracts templates. So even when we started the company in 2021, anyone who purchased a template received the newer versions in 2024. And so what I did was I added in this clause, and I added it in because I read a court case where the court saw that there was a limitation of liability in the contract, the clause. And the person was trying to override it and said, we can't do nothing about it because it's in the contract. And they dismissed the case. So how do you limit liability? You do that in 3 ways. You want to limit it in the amount that they can recover from. Limit it in the amount. How much can they recover? 5,000, 10,000, 1,000, or up to the amount that they invested for services. You also want to limit it based on the type of recovery. So there are different types of recovery somebody can recover for in court. I technically like to limit it to actual damages. You have to prove the actual harm to recover. So I limit their recovery options. Can I tell you something? One of the mistakes that DIY contract drafters makes is that you will draft this provision that it limits you as well. I don't limit your recovery when I draft my contracts. I limit their recovery. They are limited, not you. You want to be able to recover for everything, but you want them to be limited. So when you are reading contracts that someone gives you, you want to pay attention to that language as well. That way you know what you can recover for. And then the third recovery, and y'all gonna love this. When I found this, I love this. You want to limit their time to bring a lawsuit. Some of you, I know you're on your devices. I want you to do me a favor. If you're online right now, I want you to do me a favor. I want you to Google this question. What is the statute of limitations for a breach of contract in, and I want you to put your state. What is the statute of limitations for a breach of contract in, and I want you to put your state. And if you see two answers, I want you to only focus on written contracts, and I want you to drop your state, and I want you to drop the number of years that show up in the comments. You can do this on Facebook as well. What is the statute of limitations for a breach of contract in your state? Put your state and put the answer that pops up. Texas has a 4-year statute of limitations. What else? That's 4 years. All you gotta do is put your state and the number of years. Your state and number of years. Y'all can do this too if you're on Facebook. State and number of years. What you come up with? Maryland, 3 years. 3 years. Come on, I know we got some other folks. You can do this too in South Africa. South Africa got one. Hey, Vicky, welcome. I want you to Google what is the statute of limitations for a breach of contract in, and put your state. Come on, y'all. What you got? Look, if you in a different state, I don't know your answer. I don't know your answer now. I'm gonna tell you that now. I don't know what your answer is. All right, so without okay, searching South Carolina. All right, Vicky. Okay, so all you gotta do is put your state in the number of years. Georgia, 6. Oh, I didn't know Georgia was 6 years. 6 years in Georgia. Oh, that's too long. Oh, okay. All right, you're gonna understand my reaction in just a moment. I'm trying to wait for you, Vicky. I'm trying to wait for you. The statute of limitations is how long someone has to sue you. That means in Maryland, somebody got 3 years to bring a lawsuit. Virginia, 5 years in Virginia, 6 years in Georgia. That's how long they have. 3 years in South Carolina. That's how long they have to bring a lawsuit. But only if you had a limitation of liability clause in your contract. Woo-wee! Oh, you could limit the amount of time, baby. And so a best practice, I'm gonna give you the language. I'm gonna give you the language I use. The best practice is 1 year. And what I like to put is already, if you have a 180 contracts template, it's already in your template. It's already in your template. It's already in there. Look, remember I said one of the mistakes that DIY contractors makes is they limit themselves. Don't put no limitation on you, put it on them. The client, or whatever language you're using, the client must bring any legal claim or suit under this agreement within 1 year of either the termination of this agreement or the action that gave rise to the claim or lawsuit, whichever comes first, or they are forever barred. What I just said was that if you're in Maryland 3 years, if you're in Georgia 6 years, Virginia 5 years, South Carolina, where do I get contracts from? You go to 180contracts.com, Lavani, 180contracts.com. And if you don't see what you're looking for, you can use our suggestion box. We are taking suggestions for what contracts to add to our contract family. So you can add a suggestion and we will add that template for you. Yes, it has to be in the contract. Because here's the thing, for some of you, if it's not in the contract, that means that state law governs. So when we said venue selection clause, right? If somebody were, say for instance, you are in Texas, or let's say you're in Maryland. Maryland is 3 years, but the client is in Georgia. They got 6 years to bring a lawsuit. Y'all, I don't even remember some people from 5 years ago. And so if you haven't followed some of the tips and kept records and all of that, that means you don't have evidence. Let me tell you something. Keep track of text messages too. If you use text messages, you want to screenshot that and upload it into your client file. if you do videos, sorry, I covered it. If you do videos, you want to do two things. You want to upload the video file, but you also want to take a screenshot that shows the date and the timestamp of the video. The reason why I'm telling you this from a litigation standpoint is you want to be able to have your proof, because your phone may delete text message. You might lose your phone and you don't have that anymore. That evidence is gone. And so if you don't have a limitation of liability clause that limits how long they can bring lawsuit, then that means you would have to, remember we said keep records. You would have to keep that record for 6 years if you were in Georgia, 3 years if you were in South Carolina. You would have to keep that record for 5 years in Virginia, 3 years in Maryland. That's how long you would have to keep those records. So you want to make sure that you understand what the statute of limitations are, but put a limitation of liability clause in your contract. So when you limit that time, if somebody comes into court and try to sue you, and it's after the 1 year, if you put 1 year as the limitation and it says they are forever barred, you know what's going to happen? Even if you have to go to court, what's going to happen is that, Judge, I motion that this case be dismissed. Based on the contract, they had 1 year to bring this suit and they failed to do it. Do you know how much that saves you in time, money, litigation? Even if you got to go to court, it just saves you that. All right. Hey, Crystal. Hey, Crystal. All right. And so you want to be able to have a limitation liability. You limit them in the amount that they can recover for, the type of recovery. I like to do actual damages only. And then also the time, how long they have to recover. All right. And then last but certainly not least is contract tip number 15. After I do this, I'm going to close the live. So I want to thank those who tuned into the live. You can go to 180contracts.com if you're looking for contracts. If you want to be a part of the Lunch and Learn, you can sign up for our email list. You can register. Our next Lunch and Learn will be on Friday, May 9th, same time. And we're going to be talking about asset protection and wealth preservation. Asset protection and wealth preservation. So in the same link, you can go to bit.ly/lunch and learn, all lowercase 2025 to register for that. But Q&A is only for those that register, and there will be a replay for you guys. So don't worry about that. All right, so let's get into contract tip number 15. It's to secure your intellectual property. Y'all know I wasn't going to do no tip and forget intellectual property. Is one of the most important things. You want to secure your intellectual property. And to do that, you need to understand intellectual property. So what do I mean by understand intellectual property? Facebook Live, so the Facebook Live is actually on my personal page, y'all, because I don't have enough followers on 180 Contracts. We just rebranded. I'm trying to take this social media thing more seriously. But apparently I got to have like 60 or 100 followers before I can go live. So I did it on my personal business page, but it will be posted on our YouTube page, and that's at the 180 Contracts, the 180 Contracts. So this will be posted on the YouTube page, but you can search 180 Contracts, and it'll be there after. I'll post it there after this is over. All right. All right, so I know we're running on time. I apologize if I said 30 minutes, but I didn't realize I was going to give y'all extra stuff and go on. So I'm going to try to get to it. Okay, IP, intellectual property. So first you have to understand intellectual property. So you probably are familiar with trademarks. You probably understand a little bit about copyrights, but not to the great extent. And so remember when I told you in the beginning, tip number 1, never put your individual name at the top of the contract? Intellectual property is where I deviate from that. I make an exception, and here's why. When we get to copyrights are creative works that are created, and copyright protection automatically applies when it's fixed in a tangible format. So the moment this book was in a tangible format, copyright protection applies. This recording right now is not, copyright protection doesn't apply until we finish this recording. So while I'm streaming, copyright law doesn't protect it. Now, some of you might think you have to register your copyright for protection. No, you get the copyrights when you create it. But when you register, you get the ability to sue for copyright infringement. Now, here's the thing that you may not realize is that copyrights belong to the original creator. So if you have your child, your cousin, somebody else take photos for you, or you hire someone, they are the copyright owner. Who created it? The only way you become the owner of copyrights is if you have a contract in place. So if you want to own it, you got to put a contract on it. And the contract you put in place is an intellectual property assignment agreement, or it can be a copyright transfer or copyright assignment agreement, because this agreement is only if this is after the fact. The way that you get your intellectual property protected is you put it in your existing contract. That way you're not fumbling with somebody after the fact. Now here's why I make the exception if I was doing an IP assignment agreement to put the person's individual name at the top. When you are in your business and you don't have a contract in place that says the business owns it, or you're not a W-2 employee of your business, you personally are the copyright holder, not your business. Because you're the creator. You need a contract in place to transfer that right and make the business the owner. But if you are a W-2 employee, the employer automatically owns the copyrights of the employees. So therefore, if you're on payroll, now your business owns the intellectual property. But if you have someone else creating intellectual, so they're so glad they didn't. Thank you. If you hire a contractor, the contractor owns the copyrights. This is why everything is not a work made for hire. I've seen contract templates say it's a work made for hire. No, it's not. It's a statutory definition of what counts as a work made for hire. And not everything a contractor does will actually transfer to you. So you need to have language in there. The language they transfer and assign all right, title, and interest of the intellectual property to your business. Okay? To your business. Now, the reason why I typically say your business is because your business has liability protection. So it shields your personal assets as long as you do business right. Now, okay, let me get into this. Anything created by AI is not protected by copyright law. Anything created by AI is not protected by copyright law. So when we talk about securing your intellectual property in your contracts, because AI is on the rise and AI is, people are using AI to shortcut. Look, there's some folks who, I can do the work and they're using AI. You want to put in your contract, if you don't want AI to be used, you are prohibited from using AI. If you allow for AI, you can even do this. If you don't want to do a blanket like block, you can put in your contract that any use of AI must be approved prior to your use. Every use of AI, your company has to approve it first in writing. This is how you make sure, this is how I write grace into the contract. If we don't want to just put a ban, then we just say, well, you got to get my permission before you use it. Now, if you're going to use AI and you want to have that right, you can put in your contract that we reserve the right to use AI. And for certain pieces of content, regardless, is you want to know what part was created by AI and what part wasn't. That way, if you do pursue copyright registration, you can identify the copyright protectable elements versus the ones that are not. Now, look, in my other capacities, my other hats, yes, I teach this. I know we focus on contracts, but you're gonna get a little bit of all of what I do right now. Okay, so you want to make sure you have protections with AI. Other thing, protecting your AI. There is a difference between ownership and licensing. There's a difference between ownership and licensing. If for some of you, if you have a 180 contracts, you immediately get contracts decoded. That's an ebook that I created that it literally will decode all of this. It breaks down ownership, license, and even give you some drafting tips. All of that is for you when you get a 180 contract. You get it because you need it, okay? So ownership, you need a contract to own if somebody creates. Licensing will happen if you have a contract or not. And so you want to be clear what part of your business and what you have are you willing to allow for a client to license and use. And you want to be clear what that licensing is. So when I do my ebooks, because that's a digital product, I put a license in place in my terms and conditions. And you can even see, if you ever get an ebook from me, you will see on the legal page that there's a licensing. And that licensing tells you what you can and cannot do, because copyrights come with a bundle of rights. I know you probably think that a copyright is one, but it's actually a bundle of rights. Depending on what you look at, is either 5 or 7. And so it's the right to broadcast. It's the right to distribute. It's the right to publish. It's the right to print. And so you want to make sure that you are very clear on what rights you are giving to people who purchase from you or your clients. That way, if you don't want somebody selling your stuff, you write it in. You cannot sell this. You cannot post this on social media. You know how posts like to do. Oh, this is good. Let me put it on social. And now your copyright stuff is all on the internet and people trying to snatch it. No, that's what we're not doing. And it also gives you the legal right to take action if they do that. All right. What else I got on here? Because I know we get into time. Oh, let me say this. This is why when I do an IP assignment, this is why I put the individual name at the top. I told you that copyrights, if a person doesn't have their business set up where their business automatically owns the work that they do, then that means that they're still the individual owner. So if you had just put their business name at the top, it's a possibility you didn't get the proper rights because the business didn't own it, the individual owner does. So I will put my business name at the top, and I will put the business of the other person who created the work for me and their individual name to make sure the copyrights properly transfer. So 180 Contracts went through a rebrand. I had someone design my website and the logo. I sent them that contract. I sent them the contract to make sure I own the rights to the logo as well as to any content on the website. If you have anyone that's building something for you and they're giving you photos, make sure you get the license agreements for the photos, because copyright infringement don't care whether you knew or not. It is strict liability. So if you have a photo that somebody didn't have the copyright license to or permission to use, now someone can sue your company because it's on your website. Okay, I was in a lawyer group and I just saw, I think earlier today, where somebody was coming after an attorney for a photo they used in a Facebook post years ago. So you want to make sure that they have the proper licenses in place. You have copies of them, and you too. And you can even get royalty-free license and images. Okay, you can get that for free. Music too. It's all available. Just look for royalty-free, copyright-free, and pay attention to the license. All right, so we're talking about securing your intellectual property. I think I covered everything. Y'all. I think I covered. So let me just go over the contract tips, and we're going to get ready to shut this down because we are at time. So tip number 1, never put your personal name at the top of a contract except what I mentioned in tip number 15. Contract tip number 2, negotiate before the contract is signed. 3, use a e-signature software. 4, keep track of your duties, key dates, and timelines. You want to create a cheat sheet, especially so that you know any renewal options, notices, and termination when that pops up. Number 5, have a storage system for your contracts. Number 6, follow up conversations in writing and identify the people that were on the call. Number 7, keep receipts. Number 8, put in writing only what you are okay with showing up in court. Number 9, add your policy to your contract so that they have to comply, because they can violate the policy but not the contract. Number 10, document problematic behavior, violations of policies or contract, and put corrective action. Tip number 11, terminate with professionalism and integrity. Number 12, use clear terms and consistency. Number 13, have a venue selection clause. Number 14, have a limitation of liability clause. And number 15, secure your IP and understand your IP. So for those of you who are in the Zoom, give me one moment. We are going to transition to our Q&A. So if you hear recording stop playing, stay. And for those of you who are joining on Facebook, thank you again. Check out 180contracts.com. Make sure you follow us on Facebook, Instagram, and YouTube at the 180 Contracts. And if you want to be a part of the Lunch and Learns, you can subscribe to our email list and register. Our next one will be on Friday, May 9th, 2025, same time, 1 p.m. Eastern Standard Time, and whatever that's translating to your zone. And you will get access to the replay. But if you sign up, you get access to the recording for the Q&A session. And on May 9th, we are talking asset protection and wealth preservation. So that is all. Thank you for joining. And I am ending this live. All right, y'all. It's been a while since I went live, so I hope I ended it right. Oh, y'all, hold on. Oh, they didn't change the settings. I'm gonna be deleting my live. Okay. All right. Now that we got that done, let me end this and we're going to transfer on over. Hold on. Give me 1 second, y'all. All right.